Broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone.
Muted. Unmuted.
My name is Miriam Aliso, and I would like to welcome you to today's webinar. Before we get started, I'd like to go over a few items so you know how to participate in today's event, which is FERPA and IDEA Privacy Requirements 101 for Parent Centers. You will notice on your screen a screenshot of an example of the GoToWebinar interface. You should see something that looks like this on your computer desktop in the upper right corner. You are listening in using your computer's speaker system by default. To the right of the GoToWebinar PowerPoint viewer is the GoToWebinar control panel. This is where you have the option to select the way to hear the webinar, raise your hand, and ask questions by text. You will have the opportunity to submit text questions to today's presenters by typing your questions into the Questions for Staff pane of the control panel. You may send in your questions at any time during the presentation. We will collect these and address them during the Q&A session at the end of today's presentation. You can also download the webinar handout and the slides. They are available to you. Then I pass the torch to Carmen Sanchez.
Hello, Parent Centers. This is Carmen Sanchez. I'm either your project officer, but I'm also the Parent Center program lead here at the Office of Special Education Programs. So this is one of the roughly quarterly webinars we have with you around topics that are of interest to the entire Parent Center network. And one of the questions that were asked quite a bit were having to do with both the FERPA requirements and whether or not they apply to Parent Centers, but also just the FERPA requirements generally in families, and also some of the IDEA privacy requirements. So because of that, we've gotten we have two colleagues here from the Department of Education who are going to address both of them during this presentation. They're Frank Miller, who is acting deputy in the Student Privacy Policy Office, and Kailasha Supranant, who's general counsel in the Office of, she'll explain her title, in the Office of General Counsel. We're going to discuss these very important topics with you, and then we'll go over some of your questions. I also just want to draw your attention to the fact that you can download the FERPA presentations, as Miriam pointed out in the handouts, but they're in Adobe Acrobat because they cannot be changed. We know that they're legally sufficient in the way that they're written right now, but we cannot have you change any of that. But you're free to use them, and you're free to use them with your families. So without any further ado, let me turn it over to Frank and Kala to present this presentation on the FERPA and IDEA privacy rights. Thank you.
Good afternoon. This is Frank Miller. I'm the Deputy Director of the Student Privacy Policy Office. This is a relatively new name for our office. For years, we've been known as the Family Policy Compliance Office. So I'm glad you're able to spend your afternoon with me as we discuss IDEA and FERPA. And I'll turn it over to Kala so she can introduce herself.
Thanks, Frank. This is Kailasha Supranant, Senior Counsel in the Office of the General Counsel. I've been with the U.S. Department of Education for almost 20 years. And have spent a lot of time answering questions about IDEA, worked on both IDEA Parts B and C. I work on other matters as well for the department, but one area that has been of critical interest to me is the area of privacy and confidentiality, so we look forward to the presentation today. Next slide.
So this afternoon, we hope to cover a couple different things. As you can see, we're going to talk about 3 different statutes, IDEA Part C, Part B, and FERPA. And we're going to talk about how there's some similarities between the 3 statutes, how they're slightly different, and how you can kind of read them together as you answer questions that may come up during your normal course of business. Next slide, please. this is kind of reiterates what I said before. So you're going to see, we're going to walk through several sections of the statutes. We'll break them out and address them and kind of show the commonalities, the differences, and then how we can work together to resolve some of the conflicts as you read the two together. I'm going to turn it over to Kala now, and she's going to kind of give us a little bit of a background of who we are per se. Next slide, and Kala.
Thanks, Frank. So our oldest privacy statute in the educational arena is FERPA, and FERPA was enacted in 1974, last major set of regulations in 2011. IDEA Part B has been around since 1975, obviously then referred to as the Education for Handicapped Act, and in 1986, IDEA was further amended to add the early intervention and preschool programs. The last major set of IDEA Part C regulations in 2011 added for the first time separate confidentiality provisions that expressly applied to early intervention programs. Prior to that time, the Part C program cross-referenced Part B, which then cross-referenced the FERPA regulations, and there were some unique twists, and it was very complicated for the early intervention programs to apply the rules. So our statutes have been around for a long period of time. They predate the internet. They predate a lot of the technology and privacy issues that we encounter today. And our regulations, while updated, haven't been amended primarily really since 2011. Next slide, please. And as you can see, the world has changed a lot since IDEA was initially enacted in 1986. Next slide. In fact, even in 1975, things were quite different. I still remember seeing Jaws as a child, being sort of permanently traumatized. But at the same time, you know, the kinds of issues that schools and teachers and of course the early intervention programs weren't even a federal program back then, the kinds of issues they faced were very different. Next slide, please. And of course, FERPA is our oldest privacy statute. In the time that when FERPA was initially enacted and IDEA was enacted after that, Congress was cognizant that there would be differences between the two statutes because of FERPA's applicability being different from IDEA. FERPA applies to educational agencies and institutions that receive federal funding from the U.S. Department of Education, whereas IDEA applies to either children with disabilities of a certain age group or young children with disabilities. Next slide, please. So these are where the three statutes are located, and the citations are here if you need to refer back to this. As I mentioned, FERPA is the oldest, and after IDEA was enacted, the Secretary of the U.S. Department of Education under Section 617 of IDEA was directed to identify and implement regulations that would be consistent with FERPA. So we try to read the statutes consistently, but we also recognize that there are differences, and we're going to talk about some of those differences today. Next slide, please. So go ahead, Frank.
Thanks, Kala. So in the various slides that you'll see throughout the course of this presentation, you'll see kind of we do an introductory slide to each section, which has a square for Part C, Part B, and FERPA. And in this case, where we're going to talk about personally identifiable information, or PII, you can see all three have some very similar languages. So that's why you see the same picture in each of the three blocks. If we can move to the next slide, please. So let's talk about personally identifiable information. We hear that term thrown out a lot in the context of privacy and student privacy. It obviously contains some of the more common, obvious themes, right? Name, mother's maiden name, address, date of birth, social security number, some really common things that when we think of personally identifiable, those probably come to mind right away. However, we also, under FERPA, have added some additional clauses. So if we could go to the next slide, please. In FERPA, we added two different caveats back in 2008. As Kala talked about, we had some different, over the course of time, we've done some re-regulation and re-amendments, but in 2008, we added two different components to our PII definition. The first is the first bullet, which basically it talks about anything like in combination or linkable together would allow anybody within the school, a reasonable person within the school community who doesn't have personal knowledge to identify the student. So we usually do, if I was on an in-person presentation, I do a little story about Peter Pan and Captain Hook, in which case I say if we talk about a student who has a wooden leg, a patch for an eye, not saying the name, but having this couple of identifiers, you can piece it together that we're talking about Captain Hook. So that's kind of what we get at with this first bullet under PII. It's those things that, although individually they might not be PII, but when you put that together, you can figure out the identity of the student with reasonable certainty. The second caveat is information requested by a person who the educational agency believes knows the identity of the student. I kind of like to call this one the media request. So somebody from the media is requesting information, but they really know who the individual is. They're just trying to get some background for a story they're doing. So those two things are a little unique to FERPA in that we've added them in addition to kind of the more common things you would think of under PII. And I think now I'm going to turn things over to Colin. She's going to talk a little bit about how IDEA discusses personally identifiable information. Colin?
Next slide, please. So the good news is the definition of personally identifiable information, or PII, is really the same across the three programs. IDEA Part C has some translation provisions where the term child is substituted for the term student, and where the term school is used, it's early intervention service provider. With Part B, while the language seems slightly different, the reasonable certainty language that the Captain Hook example, if you will, as Frank mentioned, is really the same idea under Part B. So there really isn't a substantive difference. And for those of you who are in the early intervention world, you may recognize, or you may have programs that also have to comply with HIPAA. And as you know, unlike our educational statutes, which protect personally identifiable information, HIPAA protects something called PHI, or health information, personal health information. So we're not going to talk about PHI today, but I wanted you to make sure that folks understand that PII is what we're talking about today. Next slide, please. So now we're going to transition and talk about what records are covered, to whom do these rules apply, and when do these protections come into play. Next slide, please.
So as we look at what records are covered, you'll notice when we did the first kind of snapshot of the smiley faces under PII, they were all similar because all three of the statutes basically said a lot of the same components. When we talk about what records are actually covered, however, you can see we have three different smiley faces because each of the three statutes have some unique nuances. Starting and really building upon what we have as a foundation under FERPA. So if we go to the next slide, please. And I'll start, I'm going to talk about the FERPA side of things. Under FERPA, in terms of education records, there's really two basic caveats that they have to meet. Are the records directly related to a student, and are they maintained by the educational agency or institution? So it's a pretty broad definition, but it has those that two-pronged caveat. And why that's important is, as Kala said, FERPA was written in 1974. So that was pre-internet, pre-email, pre-online school, record portals, et cetera. So it's really almost medium neutral in that if the record is directly related to the student and maintained, under FERPA, that would be considered an education record. I'm going to turn things over to Kala, who's going to talk a little bit about how that carries over into IDEA Part B and Part C. Kala?
Thanks, Frank. So the same two standards apply in that the record has to directly relate to a child or student, but the second part is a little broader under IDEA. The IDEA language refers to records that are required to be collected, maintained, or used Or sometimes we paraphrase it in the regs to say records that are collected, maintained, or used, suggesting that's even broader, not just those that are required to be collected, maintained, or used. And this becomes complicated because we have now records that are maintained in cloud-based systems, and it's not always clear whether the EIS provider or an LEA or a school is maintaining those records. Often our analysis is very case specific, but I wanted to pause on this slide because so many of the questions we receive, you'll want to go back and look at the regulations in this space, both under Part C, under Part B, if it's a question for a child with a disability, and under FERPA. Next slide, please.
So the next section we're going to talk about, now that we've discussed what's personally identifiable information and what are education records, let's talk about who has to comply with the various confidentiality provisions of IDEA and Part B as well as FERPA. As you can see on this slide, we have, again, 3 distinct faces. So that means we have pretty much 3 distinct aspects of who must comply. And we're going to start off with Kala. If you can go to the next slide, please.
So under IDEA, it is the participating agency, both under IDEA Part C and under IDEA Part B, that must comply with the confidentiality provisions. What does that mean? Who is the participating agency? It's any individual agency, entity, or institution that collects, maintains, or uses PII to implement the requirements of IDEA. For Part C, there are 2 additional provisions. It includes an individual or entity that provides Part C services of any kind. That can include service coordination, evaluation, whether a child is determined eligible or not. And finally, there's an exception to the definition of participating agency, and that's the 3rd bullet on this slide. The definition excludes entities who are served as primary referral sources, and a common question we receive in this area is whether EDI programs, physicians, and others who refer a child would be included in that umbrella of a participating agency. And the answer generally is no, although there can be some exceptions. The second exception are agencies or entities that act solely as funding sources for Part C services and are not part of the state lead agency or early intervention service providers. For example, a Medicaid agency, where the state lead agency is the SEA or the state educational agency or another state agency. I want to pause here because a lot of the time our questions that come in about whether or not information can be shared with or without parent consent often hinges in Part C on this definition, participating agency. Next slide, please. And as I mentioned, the definition of participating agency in the Part B is very basic. If the agency is responsible for implementing Part B, it then must ensure that that information that's maintained or used, that PII, is protected. Next slide, please.
So let's talk a little bit about who must comply with the FERPA provisions. And our big thing is we apply to educational agencies or institutions. And as you can see by the definition, we have 2 caveats: any public or private agency or institution that provides educational services. So think of it simply as any elementary school, secondary school, university that receives federal education dollars from the U.S. Department of Education under the control of the Secretary. We often get a lot of questions, well, what about a private preschool or a private school? And typically, a lot of your private schools, your parochial Catholic high schools or different of that sort, they would not have to technically comply with FERPA because they're not receiving U.S. Department of Education funds. So we'll get calls from parents that are having difficulties with some of their child's education records, but they go to a parochial school and there's nothing that our office can really do to assist. I know in some states from my interactions, they may have requirements that a private school follow certain guidelines similar to FERPA, but in terms of the oversight of our office and the federal statute, it's only those schools that receive U.S. Department of Education funds. It gets a little trickier, and not so much in this place, but for the post-secondary arena, because almost all the private universities do participate in federal student aid, which is, the biggest funding stream from our department. So a university may be a private university, but they're receiving, federal student aid, so they would then have to follow and comply with FERPA as well.
And Frank, I just want to mention, and there's one limited instance under the IDEA when a state lead agency or a state educational agency has publicly placed a child in a private entity, like a private school. Then in that very limited instance, if those federal funds are used for that, say the one child who's placed in a private setting, then the FERPA and IDEA provisions would carry with that child, not to the whole school, but to that child who's been publicly funded.
Yes, thank you for that. Yes, we have gotten questions of that, and I think exactly as you said, Kyle, it would, especially like the FERPA side, would apply to the records of that sole student. It wouldn't mean the whole private school would have to comply with FERPA, but just the records pertaining to that one individual student. Okay, next slide, please. Okay, so we've talked about who the confidentiality provisions under FERPA and IDEA apply to, but now let's talk about when they actually start applying, because there are some differences, as you can see, across Part B, Part C, and FERPA. We all have, there's a little slightly different nuance as far as when those confidentiality provisions do apply. Next slide, please.
So there are a few differences. Part B and Part C of the IDEA are clear that once a child is referred to the program, regardless of whether that child is determined eligible or not, the confidentiality provisions apply. That means that the same rights of access to information by parents, the obligation to maintain confidentiality of personally identifiable information is important. And Part C is a little more recently promulgated in terms of the regulations on this. So there's an additional provision about when that obligation ends. We added those provisions in our final 2011 regulations in great part because we had additional changes from the EDI program, from the CAPTA program, where a number of children were being referred to Part C, but not necessarily being determined eligible. So Part B and Part C are similar that way. One additional difference for Part C, although I would argue it's probably the same substantively for Part B, we don't have specific regulatory language, and that's the when does that obligation end, and that's the language you see there in the reg, until the later of when the participating agency is no longer required to maintain or it no longer maintains that information. So that's when it ends. Basically, as long as you have it, you have to keep it confidential. Next slide, please. And you can see it's the same for Part B. Next slide, please.
So let's take a look at what FERPA has to say about when the confidentiality provisions apply. And here we're a little different because under FERPA, it's when the student is in attendance at the educational agency or institution. So that's kind of critical because, and especially, again, more so in the post-secondary side where a student is applying for admission and maybe never actually attends that university, those admission records would not be covered under FERPA because the student was never in attendance at that agency. So that's a little difference in that we focus on a student being in attendance. Now, we often get questions of, well, under FERPA, how long does a school have to maintain those education records? And FERPA is really silent on that aspect. We don't have a specific time frame. Kind of goes similar to what Kyle said under IDEA. Basically, those records, as long as the school maintains them, have to be maintained consistent with FERPA. So there's no prescribed time frame on how long, but as long as they're being maintained, they have to be maintained under the confidentiality provisions according to FERPA. Next slide, please. Okay, so we've talked about what's PII? What are education records? Who has to maintain them in accord with the confidentiality provisions? Let's now take a look at whose records are actually covered. Next slide, please.
So under IDEA Part C, the definition is fairly broad. It's any individual under the age of 6, because states do have the option of serving children and offering parents the option of providing services through age 5. Next slide, please. And under IDEA Part B, it includes all children with disabilities, as well as records related to children who are referred to the program, as I mentioned earlier, and who aren't determined eligible. Next slide, please.
And again, looking at FERPA, pretty much what I said a few slides ago, the records are covered are those that are of a student. So it's a student's education records, and again, any individual who's actually in attendance at that educational agency or institution. So we focus more on students. Next slide, please. So over the next couple slides we're going to move into, we're going to cover 4 basic or primary areas. We're going to look at, again, confidentiality, more so consents to release information. We're going to talk about inspection and review and amendment of records. We're going to talk again a little bit more about the obligations to retaining records. And then we're going to finish up this kind of different section with a discussion of dispute resolution. So if we go to the next slide, please. Let's talk about basically what is the definition of consent or consent to release under the 3 statutes. And as you can see, we're going to have some similarities between Part C and Part B. And once we get to FERPA, just a little nuance. And I think Kyle is going to start us off with talking about Part B and Part C. Next slide, please.
So the definition under IDEA for consent is the same, and it is a long-standing definition. It is a definition that doesn't just apply in the context of consent to disclose personally identifiable information. The general rule in IDEA, as well as under FERPA, is unless the statute expressly authorizes a disclosure, you need an exception to the general rule that you cannot disclose personally identifiable information in a child's record without obtaining prior written parental consent. And that's common across all 3 programs. The emphasis under IDEA on the definition of consent is that it not just be written, it also be voluntary and informed. So if there are questions from a parent about what the meaning of what they're consenting to, and if the document itself is very unclear about what they're consenting to, and this is the same definition that applies to consent for services as it would to the consent to disclose personally identifiable information, then an oral explanation or other explanation should be provided in the document. We have had questions come up in this area as well. For example, there are times when primary referral programs want to try to get consent from families early on in the process when they refer a child to the Part C program. For example, the EDI program may want to get information as they refer a child to Part C about what happens with the child, because they have tracking and other data that they have to report, and also because they want to ensure that that child does not slip through the cracks. If they want to get that consent such that it would hold up under IDEA, they would have to ensure that the explanation identified the kinds of documents or information that could be shared back with the EDI program. For example, determination of eligibility, or if a copy of the IFSP, for example, would be shared. So it has to be somewhat detailed. That is broader than the FERPA definition of consent. Next slide, please.
So let's take a look at consent under FERPA, and you'll see we have some definite similarities to what Kala talked about. It has to be signed, it has to be dated, and it has to be written. So there is no verbal consent to disclose under FERPA, for example. We get questions a lot in terms of what do you mean by signed, and would an electronic signature work? And we have some specific provisions that it could be an electronically signed consent. I think while FERPA itself doesn't specifically talk about the consent being voluntary and informed. I think that's certainly kind of the thought behind it. But one of the things you'll see differently is when you look at the regs under IDEA, they specifically state voluntary. You're not going to see that same, and informed, you're not going to see that same language under the FERPA side of things. Next slide. So we just talked about, again, getting what needs to be in those consents, and typically before any information can be shared, you have to have the prior written consent of the parent, unless there is an exception. So over these next couple slides, we're going to talk about some of the different exceptions to prior written consent. And as you can see, we have some differences across the three statutes. Kala, do you want to start us off by talking a little bit about the exceptions to consent under Part C?
Sure, thanks, Frank. So this slide is probably out of order because the general exceptions that you would think of are primarily under FERPA, and Frank is going to talk about those as well. But there are some that are unique to IDEA Part C and Part B. Two of the definition or exceptions that are unique to Part C include what I mentioned earlier, the definition of a participating agency. Often, an individual or an entity will be part of what I call the Part C umbrella within a state, part of that statewide system of delivering early intervention services, whether that's a professional on the evaluation team, the service coordinator, an early intervention service provider, an individual who may be working both with a payer of Part C services, but also is involved in the delivery of perhaps family services. So while it's not a true exception, many, many times we have inquiries from states, and as we probe further into how Part C is implemented in an individual state, we'll discover that the definition of participating agency may be broad enough in that state to allow for what I call the non-consensual disclosure. Basically, there isn't a need to get prior written parental consent. That's the first bullet. The second bullet is what we call the transition notification or opt-out. When a child exits from the Part C program, typically at age 3, they may be referred on to the Part B preschool program, and in 3/4 of our states, those two programs are administered by two different state agencies, where the state lead agency isn't the state educational agency. Our regulations permit the state lead agency or an agency under it to provide basic child find information to the parent by the state educational agency or the school district that would pick up that child at age 3 and conduct an evaluation under Part B, unless the state has adopted in writing a written opt-out policy that informs parents that they have the right to opt out of that basic child find referral, which some parents do elect to do. They just don't want to start the school district relationship for their child with kind of the history coming back over from Part C, or even the fact that they had been served under Part C. So that you'll have to know whether your state has an opt-out policy, but if it doesn't, then that notification can occur, and that's an exception to the disclosure generally. The general rule that the disclosure occur only after prior written parental consent. Next slide, please. And these are the translation provisions to apply the FERPA exceptions to the Part C program. Next slide, please. In addition, under IDEA Part B, there are specific exceptions because children at some point become no longer treated as legally as children in their state when they reach the age of majority. So in most states, that would be around the age of 18. And at that point, this child also has rights to receive information in addition to the parent under IDEA Part B. And as noted on the first bullet, officials of participating agencies also have the ability to receive information and disclose and share PII without prior written parental consent. Both IDEA Part B and Part C also incorporate the FERPA exceptions, and Frank's going to talk about 4 of those. Next slide, please.
Thanks, Kala. Under FERPA, we have about 14 or so exceptions to prior written consent of varying varying degrees. And I think for sake of the time of our session today, we don't have a chance to cover all of them. So as Kyle said, I'm going to go over 4 of probably the more pertinent to this audience. You'll see one of the handouts that we have added is a crosswalk between FERPA and IDEA's Part B and C. That's going to have a listing of all the exceptions, so I'd encourage you at a later time to take a look at those. But let's talk about 4 in particular: audit and evaluation, the Uninterrupted Scholars Act, compliance with judicial orders and subpoenas, and health and safety. Next slide, please. Audit and evaluation is typically how most state educational authorities gain data that they need to do for data reporting, compliance with federal legal requirements, and really doing an audit and evaluation of that federal state-supported program. And so accordingly, FERPA has an exception that allows schools to disclose information to those federal, state, and local officials. We also have a thing called the authorized representative of those officials to do an audit evaluation or enforcement of and compliance with federal legal requirements. And there's some caveats to that as far as the information can only be used for the audit and evaluation. It should be destroyed after it's no longer needed. So there are several aspects of that, but in general, the audit and evaluation exception is really how SEAs can either get the information directly to do their data reporting or have an entity do an audit and evaluation on their behalf. That's the audit and evaluation exception. Let's go to the next slide, please.
And actually, Frank, I just wanted to mention the audit and evaluation exception has been used in some of the state longitudinal and early childhood data systems. This is fairly complex if your state is just in the process of reviewing how it might be able to share data in this context, and we strongly urge you to communicate with the department, and we'll have some resources identified at the end. Thanks, Frank.
Yes. Thanks, Kyle. So let's take a look at the Uninterrupted Scholars Act, and this is our most recent exception to consent. It was implemented in 2013. And what had happened back in about 2006, we had a Fostering Care Connections Act, which was the first time they really talked about bringing together the educational system and the foster care community to make sure those children that were placed outside the home in foster care, that their education wasn't unduly interrupted because of the fact that they were put into placement. So the Fostering Care Connections Act was a great thing. The only problem was it didn't address the actual disclosure of education records between children and youth agencies and the schools, which would be prohibited by FERPA. So in 2013, President Obama signed the Uninterrupted Scholars Act, and that does a couple things. It permits the disclosure of PII, which we talked about earlier, from education records from children in foster care. So basically the school can disclose information to the child welfare agency of a child that is placed in foster care. And it's kind of hinges on the aspect in dealing with our various local state and local children and youth agencies. It hinges on who has access to the case plan. And it's really, again, specific to those children in foster care, placed outside the home. I know a lot of states, as a former caseworker myself, we have children that are under protective services where the children and youth agency may keep a presence in the home, but the child is still in the home. The Uninterrupted Scholars Act would not come into play in that situation. Same with the juvenile justice system. We have a separate exception that kind of talks about some of that, but we've had cases where juvenile justice have tried to use the Uninterrupted Scholars Act, and it doesn't work. It's strictly for those children that are placed in foster care. Next slide, please.
And in the IDEA context, the Uninterrupted Scholars Act may come into play when you don't have a clear parent and you may need to appoint a surrogate parent. There's a consultation requirement in the IDEA Part C regulations, and this is the exception that would enable that caseworker from the child welfare agency to speak with you.
Thanks, Kala. It's a good point to add. So let's take a look at compliance with judicial orders and subpoenas. And this is kind of makes sense. So a lot of times either that may be a case where a student is involved in some legal proceedings. It could be a lawsuit, but once the school is presented with a judicial order or lawfully issued subpoena, they have to act on it. And under FERPA, we say they can make that disclosure consistent with the judicial order subpoena without parental consent. There is a stipulation in that the school must still make a reasonable attempt to at least notify the parent or eligible student that the order subpoena is received. There are a couple exceptions to that if it would be a grand jury subpoena, or there's a couple different caveats that if it's a certain type of subpoena that the school wouldn't have to make a reasonable attempt. But in general, school gets a subpoena or judicial order, they make a reasonable attempt to notify the parent, and then they act on that judicial order or subpoena. Anything you needed or wanted to add to that, Kala, in the IDA context?
No, thank you.
So let's go to the next slide, and we'll talk about the last exception to consent that I'll be discussing. I think this is probably one of our more important, if I were to rank order our exceptions to consent, and that's the health and safety emergencies exception to consent. Really came to the forefront back in '96 with the terrible occurrence that happened at Virginia Tech and that shooting. And since then, we've had, numerous other situations, unfortunately, where, we've had active shooters in school facilities. The health and safety emergency is really an exception to try to mitigate all those situations. Now, we can't mitigate them all, but we don't want FERPA to be a barrier to getting information to the right people to help avoid such a crisis or a catastrophe. So what the health and safety emergency allows is it allows for the disclosure of really any information from a student's education record that is necessary to protect the health and safety of other students. It really hinges on the fact that there has to be an articulable and significant threat. So we've had situations where certain schools or police departments, for example, would want a listing of every student on every bus route in the district just in case there was a bus crash. Now, that may very well be a good idea, but under FERPA, that wouldn't be permissible, and especially under the health and safety emergency, because it wouldn't be an articulable and significant threat. In that situation, it's almost meant to be more proactive, which this exception doesn't really cover. Under that health and safety emergency, who can be informed or provided information without consent? We say appropriate parties, and that can mean state, local, federal law enforcement, trained medical personnel. If it's a college-age student, it could be disclosures to the parents. But it's really the evidence is the school can make a disclosure as needed to prevent the catastrophe from happening. Again, the last bullet there, we talk about it being an actual, impending, and imminent emergency. And then there are some recordation requirements that if a school does make a disclosure, they have to make a notation of that in the student's education record. But that's kind of, again, 4 of our more prominent exceptions to consent. Anything you needed to or wanted to add to that, Kala, before I turn over the next slides to you?
Yeah, so overall, these exceptions are permissive and not mandatory. Do you want to just clarify what that means, Frank?
Yes, thank you. So we get a lot of questions from parents who, under some of our different exceptions, feel that the exception compels a school to make that disclosure. And as Kala said, all of our exceptions to consent are permissive in nature. So it's just a way that FERPA has a mechanism where that disclosure could be made without parental consent or the consent of a student if it's college age. But there's nothing under FERPA that compels that disclosure. That even covers to the extent of, we were talking about prior written consent. Even with prior written consent, that doesn't require a school to disclose any PII. It's a mechanism that would allow for it, but there's nothing that compels those disclosures under FERPA.
And that's the same under IDEA. So both of these, all of these exceptions we talk about, they're generally permissive, not mandatory. And one exception, of course, is under the transition notification under Part C. That is a mandatory notification unless the state has an opt-out policy.
Thanks, Kyle. So now I think if we do the next slide, and Kyle's going to talk about rights regarding access to records.
Thanks, Frank. So under IDEA and FERPA, one of the basic confidentiality rights is the right of the parent to access records and to make copies. Next slide. So under IDEA Part C, the participating agency must allow parents to inspect and review early intervention records that are collected, maintained, or used by the agency without unnecessary delay and before any meeting, such as an IFSP meeting, or in the case of a due process hearing, if one has been requested, to ensure that the records are provided access to not later than 10 days after the request has been made. Next slide, please. In addition, parents have right to copies of the early intervention records. They must receive at no cost a copy of the evaluation, the child and family assessment, and the IFSP as soon as possible after each IFSP meeting. And for any records beyond that, including an initial copy of the early intervention record, which also must be available at no cost, that's the last bullet. After that, they may charge a reasonable fee for copies of records that are made for parents if that fee doesn't effectively prevent the parents from implementing their rights to inspect and review records. They may not, under IDEA Part C, Part B, or under FERPA, charge a fee to search for or retrieve that information. Next slide, please. Similarly, under Part B, there are the same inspection and review rights as education records before an IEP meeting. And if there's a due process hearing, that request is met within 45 days of the request. Next slide. For Part B, there is the ability to charge for copies, as long as, again, that if imposing the fee would effectively prevent a parent from exercising their rights. And again, they may not charge a fee for searching or retrieving records. And that's a fee that you often see more commonly in the FOIA context. Next slide, please.
So let's talk a little bit about FERPA and can records be reviewed. So under FERPA, a parent or an eligible student has the right to inspect and review their education records within 45 days of receiving a request. You'll notice absent from our discussion of inspection and review is the term copies. So while IDEA has some specific provisions that a parent is entitled to copies of certain documents, under FERPA, not so much. So we get a lot of questions where a parent will make a request to have a complete copy of their child's education records. And under FERPA, there's no provisions that the school must provide those copies. Now, we do have kind of one stipulation on that. If the parent lives outside, and we typically say normal commuting distance. So if they, they've moved and they now want access to records, that may be a situation where a school would provide copies to a parent, but typically under FERPA, they're not required to. We're seeing a lot of that now with the online school portals. Instead of providing a parent who's long distance from the school actually copies, they will go in and give them access so they can view them electronically. So under FERPA, right to inspect and review within 45 days. Again, those education records that are maintained and directly related to a student, but generally do not have to provide copies unless there's some extenuating circumstances. If we look at the next slide, please. And we have some of the same provisions as college discussed under IDEA. They may charge a copy. If they do give fees, they may charge a copy for those fees unless it's some extraordinary amount, and that would in fact impose or inhibit the parent's ability to access his records because the fee is too imposing. And also, they can't charge a fee to search or retrieve those records. We have a very interesting letter on our website from a parent who requested access to information that was maintained in the SEA's database, and there was initially the response was that they would have to pay to have a coder come and write special code, and the amount was like $10,000 to get access to the records. So we interceded in that case, but not generally required to get copies under FERPA. And if they do give copies, they can't charge a fee for retrieval, but they could charge fees for copies, much like you see in the IDEA context. Next slide. So this is oops. I'm sorry, go ahead, Kala.
What if the records don't seem correct? All three programs and regulations include provisions that are the same and have similar process protections in place for parents. Next slide, please. So both under IDEA Parts C and B, a parent who believes that the information in their child's record is inaccurate, misleading, or violates the privacy or other rights of the child can request that that record be amended. The agency must decide whether to amend the information within a reasonable period of time, and if the agency refuses to amend the information, it must inform the parent of that refusal and advise that the parent that they have a right to a hearing. If after the hearing, the decision is reached to not amend the record, the parent still has a right to insert a statement in the child's record. I want to pause just to note that this is a right to correct inaccurate records, not to amend a substantive decision. For example, in the FERPA context, this isn't to change the letter grade on the report card. In the IDEA context, it's not to change the determination of IDEA eligibility that's been reached or goals on the IEP or IFSP. It's really if there's something believed to be inaccurate. Next slide, please. And similarly, under FERPA, it's the same rights. Sorry, go ahead, Frank.
I was just going to add, I think you pretty much covered that in the other two slides. So let's move on to the next slide. And let's take a look at record of access. This is one where it's pretty much consistent between IDEA Part C and B, and FERPA has a little different. But the general gist of this is if we have somebody who is accessing the record, and this would be somebody who's authorized or makes a request. Under the next slide, please, you can see IDEA Part C and B. It would be, the key is if it would be somebody other than the parents or the authorized representative. So if it's an outside person coming in doing an audit, for example, or it's basically capturing who's accessing the records and what did they access. If we go to the next slide, and FERPA has some similar things. This is where if we have some caveats where if it's certain exceptions where they're getting it through an exception, like if it's school officials, for example, you wouldn't see a record of access because they're accessing those records all the time. But some of our exceptions, we talk about where they have to document who has access, and that's kind of pretty standard records of access logs. And we want to make sure we leave time for questions. So let's move quickly through the last couple slides, and Kyle is going to talk about the next slide, which is how long do the records need to be kept.
Thanks, Frank. Next slide, please. So both IDEA Part B and Part C require the participating agency to inform parents when the PII that's collected or maintained or used is no longer needed to provide services. And that may be some period of time under most states with their statute of limitations. It's typically between 5.5 to 6 years, given the grant cycle and given other requirements, GEPA, statute of limits, after that child is no longer being served. And at that point, once it's no longer needed, then the information in the record must be destroyed if the parent requests that. However, a permanent record can be kept of the child's name, date of birth, and some other specific information is on that slide. Next slide, please. Similarly, there aren't similar provisions actually under FERPA. The only provision regarding maintaining records is really that they may not be destroyed as long as there's an outstanding request to inspect and review the records. So the IDEA is much more protective in this regard. Next slide, please.
So what if we can't agree? So let's say we're, a parent or student is looking at their records and there's just some disagreements in the content thereof, or they have concerns that the school has done things that isn't consistent with IDEA or FERPA. So as we can see under IDEA, we have some similarities. FERPA just a slight difference. So let's go to the next slide and I'll talk about those differences. So where there's disagreements under IDEA, you have dispute resolution processes and procedural safeguards. So you have a couple options. You can file a state complaint. There's mediation, there's due process hearings, there's IEP facilitation, various safeguards that are kind of delineated at a state level, and a parent who had concerns or felt their things they didn't agree with could follow those processes. You'll see that there isn't an OSEP level complaint process because it's really generated at the state level. On the flip side, let's take a look at FERPA. Now there is one typo on our slide. It's a reference to our old name, FPCO, but now a parent has the right to file a complaint with our office, the Student Privacy Policy Office, and we have different procedures how we would actually investigate those alleged violations of FERPA at our federal level. We strongly encourage parents to also address them at a local and state level, because a lot of times the state and local programs can actually do a more timely and also have a more case-specific processing of the complaint. But where they've exhausted those avenues, they can file a complaint with our office, and then we'll take a look at it. Anything you wanted to add, Colin, or can we move on to the next slide?
Yeah, we can move on. Thanks.
Yeah.
So what is, so these are important things to think about as you look at your own state. What are the document retention policies? Does it identify what kind of records should be kept and how long those records are kept? Who has access to that information? And what resources are available within your state? We certainly have resources we'll mention at the end, including some websites with training materials if you are looking to educate parents or others about these privacy protections. Next slide, please. And then where do we go from here? As you can see, we have a common goal under IDEA and FERPA to protect personally identifiable information, to ensure parents have rights of access, as well as copies of records in certain instances. But generally speaking, if you have a question when you're reading the two statutes and regulations together and the question involves a child with a disability under IDEA, start with IDEA first. It will cross-reference the applicable FERPA provisions. That's the most important thing to know for this slide. Next slide, please. And this is the contact information for the Office of Special Education Programs that is responsible within the U.S. Department of Education for implementing the IDEA programs, Parts B and Part C. At the bottom are website links, including a link to the state contacts for your state if you have questions about what provisions are in place within your state under IDEA. In addition, there's a general phone number, but I would recommend you start with the websites. In addition, our Student Privacy Office has some great resources available, and we work closely with their office to ensure that questions regarding children with disabilities under IDEA are answered consistently with FERPA. So Frank's going to talk about some of those resources. Next slide, please.
So thanks, Colin. I think the things I really want to point out on this slide are at the bottom, and that should really be https://studentprivacy.ed.gov. So if you go into your Google search and type in studentprivacy.ed.gov, it'll give you a link that'll take you there. But we've really worked to hone this website over the last several years, and we've made it user-friendly. It's broken out by audience. So if you're a parent, if you're a school official, you have different tabs that kind of have information clustered by the audience. We have several little training videos, training curriculums. There's several neat little videos. One's like a 3 to 5 minute overview of FERPA. We have one for school volunteers. use of email for sharing of information under FERPA. So there's several little videos that if you don't feel like reading 20 pages of legalese, you can watch a cute, funny 3 to 5 minute video that'll kind of give you the overview of several of our bigger or more prevalent topics. The other thing I like to point out is our privacy TA at ed.gov website or email address. We have a privacy technical assistance center. Several of you may have interacted with them in the past, but we staff that help desk, and that's a good way if you have questions throughout the year and you want to make sure that your understanding's on point, or you want to just make sure you're not doing anything you don't want to do, or you're concerned that it may not be consistent with FERPA. That's a place where you can send an email to that privacyta.ed.gov email address, and we'll get a response back to you. We usually try to do it within 5-7 days, depending on the complexity. It may be a little longer, or it may be even a shorter turnaround. So a good chance for you to send us questions, and we can give you some informal responses. There's also, if you go to the student privacy website, there's a contact us link that you can click on that, and that'll give you another mechanism to submit informal questions. But just a wealth of information on that website, and then we have some technical assistance resources as well. Next slide, please.
So we'd like to go ahead and open up to questions. Carmen?
Yes, I sent you some questions that we've received from the audience, and you should see them in your chat boxes if you would like to address them. One of them that's probably fairly easy to answer is the 45-day timeline. Is that 45 business days or 45 calendar days?
I can talk about that one if you'd like, Kyle. I mean, I think in the absence of where it specifies, it's always assumed to be calendar days. Now, I say that because
calendar days under IDEA.
Yeah. I say that because I am aware in my travels that, so if you think of FERPA kind of establishing 45 days, there could be a more stringent state law. I know if you're in California and a parent makes a request, they have to provide access within 10 days. So there could be, state laws that are more, again, stringent in that they shorten the timeline.
Okay. But conversely, states are not allowed to lengthen the timeline.
That's correct.
Right. Okay. And like I said,
another question.
There was also a question about a fee for redacting information. Can states charge a fee for redactions?
So it's my understanding under both IDEA and FERPA, there's no fee for retrieving records. It doesn't specifically address redactions, and that is something that may need to be done if the records relate to multiple students. I don't know that we've spoken to that issue under IDEA. Do you know if you have under FERPA?
No, but that brings up a good question, because a lot of times there'll be some confusion between what's a request for access under FERPA versus what's a request for access under like the state freedom of information or right to know laws. Usually where we see, if a parent's requesting information about their child, a lot of times there's nothing in there that needs to be redacted because they would only have access rights to that information specific to their child. But if they're making a wholesale request for different things, that's where I'll usually see the redaction come into play. So I guess just to kind of dovetail, I don't believe we've opined on the redaction, but we typically under FERPA at least don't see redaction necessary if it's the education records of their own child.
I think that's the same. So Carmen, I saw that you had a question about the IEP document.
Mm-hmm.
And I think the question was, sometimes schools don't want to email the IEP.
Right.
And that's understandable because the IEP is going to contain personally identifiable information. And the school may want to ensure that it has appropriate security standards in place. And so if they don't have a a way to encrypt that record or ensure the security of that document, they may ask that that information be provided manually. Some states have gone to cloud-based IEP forms and where there's an auto-generated email, but not all states are there yet in terms of the technology and resources. And that is up to the state.
And I talked about some of the videos on the student privacy website. There actually is, like again, I think it's maybe like a 5-minute video that kind of walks you through sending information or the use of emails as the means to disclose information under FERPA. So that kind of walks through what Kala said, some of the safeguards, dual authentication, different things to make sure that the email address you're using it's going to who you intend to.
Okay. There's another question having to do with whether or not videos of students are considered records of a child.
So that's a pretty complex issue, and I'm not sure that we could get into it given the time that we have left. I think we would be happy to talk to that person individually or follow up in that context. Are there other questions that might be shorter?
Just one caveat to that, Kala, and you're right, the question of videos are very case specific and we don't have time to go through, but on our student privacy website, we have an FAQ document specifically targeting videos and photographs that may be helpful to that individual.
Great. Another one that might be short to answer is do colleges not have to protect information after the student leaves the school?
Let me clarify that because I want to make sure what I said earlier didn't come across unclear. So under FERPA, we talk about a student that is in attendance. So that's kind of the records that are created while that student is in attendance are education records. And I try to explain that as long as the school is maintaining those records, they must be maintained consistent with FERPA. So a student graduates, the records that were created during their time in school, as long as the school maintains them, they still have to be maintained consistent with FERPA. So the student graduates, the school maintains those records, they still are covered under FERPA.
And if for some reason those records are no longer maintained at all by the school, then that's when FERPA doesn't apply because there's no record anymore, you're sort of saying, yeah.
Right. So a lot of times, some schools will destroy most of the information when the kid graduates and then keep some very basic information, which that basic information would have to be kept consistent with FERPA.
Okay. All right. Let me see if there's something else that we can...
I saw that there was a question from about if the IEP team considers a specific category and the family wanted that omitted from the documentation. I guess that's in the context of amending records and a request to amend the record. And so I guess the question being asked is that a substantive decision or is that something that's inaccurate or misleading? And of course, this is a gray area because from the parent's perspective, it may be perceived as being inaccurate or misleading. But typically in the eligibility determination process, which under Part B is done through a team, under Part C, that's the qualified professionals who make that determination. If the team considers specific information, that's part of the IEP process, and some level of documentation is typically required for the different categories that are considered. To request that record be amended to omit that information, which I believe is what the question was, would be somewhat unusual because it was part of the process of determining eligibility to look at the different applicable potential definitions of disability for which that child might be eligible. However, if as a result of that, the parent really felt strongly that a statement needed to accompany that, they could request an amendment of the record. It might be refused. And if after hearing that decision stood, the record would not be amended, there was a follow-up question with regard to that in the chat. What happens if in a state where there's a consent for mental health or other treatment, can the parent include a specific statement? And the parent can put in request that as part of the education record that's disclosed, that's put in sort of in essence their side of the story. This is not, a long novel, but an explanation perhaps of the reason why, for example, that category of eligibility was considered and why it was not really an appropriate category. So that is part of the statement that can be requested. And I believe those are the only questions I saw online. Are there any additional questions?
There is one, and I don't know whether or not this is a simple one, but it says if an agency sign-in sheet for events with spaces for multiple families to sign in, and that form also collects the child's name, disability category, and date of birth, would that be a FERPA violation?
We've actually...
That's a complex question, probably too complex for this, yeah.
No, I think Frank was going to go ahead. Frank, do you have something quick? I see what's going to be.
Yeah, I can just. I mean, what we've said, we've had situations like that, and again, if it have that sign-in sheet and other people can see another student's name, that could be potentially, and I always have to emphasize potentially a violation because of all the case-specific nuances and not seeing. I can't give a definitive, but I mean, we would have concerns with that practice. And in the past, we've talked to schools about not, sign-in sheets should be, only be able to see one line at a time. So I couldn't give a definitive, but I think there would be some concerns there. And certainly there's best practices that would be better than having one long sign-in sheet where everybody's name is visible.
Right. And that might be a good question for that person to forward on to that email you had about privacy, right?
Definitely.
For your PA center?
Yep.
Yeah. Okay. And then there's another question which I can probably answer, which is what is the intersection of HIPAA and FERPA? And the answer is probably that is a much more complicated question for this webinar.
No, but I think I'm happy to just give you a quick overview. This is not going to be an answer. But HIPAA requires that covered entities, that's the WHO, has to comply, protect PHI, protected health information. And that definition of protected health information, or PHI, includes an exception for those, for sort of the information and records that are protected under FERPA. So ordinarily, in most instances, but not all, if the records are covered under FERPA, which are true for most our K-12 schools, for example, then it's an exception, and the HIPAA rules generally don't apply. HIPAA has more than just one set of rules. It has a privacy rule, a security rule. FERPA is just a privacy rule. We don't have a security rule. IDEA doesn't have a security rule. However, we know particularly in IDEA, for a lot of our Part C programs that are placed in the Department of Health, for example, some of those programs have to comply with both HIPAA and the IDEA Part C confidentiality requirements. And that gets fairly complicated. And I have worked with many programs as the Office of Special Education programs, with the Office of Civil Rights that implements over at HHS that implements the HIPAA rule, the privacy rule. So if there are questions, we'd be glad to follow up. Reach out to your state contact and we can certainly work with you. While it's complex, most of us are familiar with the HIPAA privacy rule. If you've been to a doctor, you're quite familiar with kind of how that works. And so it's just an overlay. But in general, when you have to comply with both sets of rules, you have to comply with the more protective of the two sets of rules. And that, of course, raises more questions. But that's the general answer in terms of a 2-minute overview.
Great. Thank you. So we're at 4:14. I'm going to turn it over pretty soon to Miriam, who's going to close us out, but I want to very much thank Frank and Kala for this extremely thorough look at both FERPA and IDEA issues around privacy. And of course, you have their contact information, and also you have information for how to get in contact with the FERPA Privacy TA Center. So remember that you can download the PDFs of this presentation from the control panel on the right, and then be able to be in contact with follow-up questions. So thank you so much for everybody's participation, and let me turn it over to Miriam.
Yeah, thank you, Carmen. And yes, the webinar is recorded, and we will soon place the slides and the recording here on the parentcenterhub.org/OSEP webinar. You will find it over there, and you will also get a recording, the link. I will send it to you, so don't worry about it, because you are listening to this, or if you register for this webinar, you will get it. And let me see, there's one more slide. Thank you. And you will get a link to a survey as soon as this webinar is over. So please make sure that you respond to the survey short. And thank you again to Frank Miller and Kala Shah for your presentation. It's very valuable. And hope you can join us next time.
Thank you, Miriam.
Thanks, everyone. Bye.
Take care. Bye-bye.
Take care.